Senate Committee on Labor and Industrial Relations. Madam Secretary, please call the roll.
Mendoza?
Here.
Mendoza here. Stone? Here. Stone here. Jackson? Here. Jackson here. Leno? Here. Leno here. Mitchell?
Okay, great.
Mitchell here. We have a quorum.
We have a quorum, and we're waiting for the author to show up, so we could go ahead and begin. I believe they're on their way.
Thank you, Mr. Chair and Senators, for this, for calling a special meeting. I'm honored here to present AB 1513. This measure does something remarkable. As a result of a hard-fought compromise, the bill would establish long sought-after pro-worker protections and generates payment of significant back wages to workers, but also while relieving employers of unanticipated statutory penalties. The bill was developed by labor unions, employers, and the administration to do two things. Going forward, the bill provides for workers to be paid properly for the rest periods and all their time at work, including time when they are not doing piece rate work. Provides clear rules for employers to follow. And going backward, the bill establishes a short-term optional program for employers to make back wage payments to workers who were undercompensated for rest periods and other non-productive time in exchange for relief from statutory penalties and other damages. The legislation is an outgrowth of 2 court decisions in 2013, Gonzalez versus Downtown LA Motors and Bluford versus Safeway Stores. Thank you, Mr. Chair, for that correction, which found that piece rate workers had not been properly paid for their rest periods and other non-productive work time. These cases have generated class actions and private attorney general act cases seeking back wages and also substantial penalties from employers. Employee and employer representatives and the administration have worked hard to develop this compromise legislation to expedite payment of back wages to workers, relieve employers who pay the wages of penalties, and set clear rules going forward. We have an unusual coalition here, and I have with me today representatives of the Teamsters and Machinists, who are the unions most involved in these cases, as well as the California Labor Federation. I also have 2 of California's most prominent agricultural companies, Driscoll's and the Wonderful Company. And lastly, I have Ralph Lightstone, a representative of the administration, which strongly supports this compromise.
Thank you. We'll have those speakers step forward in support.
Barry Broad on behalf of the Teamsters and the Machinists. Our 2 unions were actually the moving parties in the litigation. We had about 100 hours of negotiations earlier in this year, and I actually have with me Karen Spencer, who is one of the attorneys that worked on the cases and was involved in the negotiations. If you have any questions, legal questions about how this works, this is not. Ordinarily, we would not agree to provide relief to employers in this situation, but what happened here is that the law significantly changed in this area. So prior to the law, basically, if the worker earned the minimum wage during the day, then it didn't really matter whether they were separately compensated for their rest breaks and meal periods. Forever, there's been an issue in agriculture and other industries where piece rate is common, that the workers would get paid for the rest break because they worked through all their rest breaks, because if they didn't work through their rest breaks, then they would get paid less. So what happened, it's not that they didn't get paid, they never rested. And it's a problem in these kind of industries because piece rate tends to be paid in industries which are very taxing physically on workers, and we want them to take their rest break, and they're supposed to be paid for it, but they're also supposed to rest while they're taking it. So that was an issue. The other problem that's arisen is that, and it's pretty easy to understand this in trucking, if you're driving the truck and they're paying you 50 cents a mile or whatever to drive the truck, that's what the piece rate is being paid on. If they then say, hey, before you get to work, could you spend 3 hours loading and unloading boxes, but that's not part of the piece rate, then you're not getting paid for all your hours worked, and it's not fair. And that's what the other case basically dealt with. So we think this is a fair compromise. It's not going to please everyone. We understand that, but we think it's a fair compromise, and we urge your aye vote. Thank you.
Thank you. Next.
Hi, I'm Tom O'Brien with Driscoll's, a berry company headquartered in Watsonville, California. I just wanted to echo what Barry said. This is an extraordinary situation. We have growers. Our growers are independent businesses, independent employers. We're following what the rules were at the time. The rules changed, and unfortunately, by application of these court decisions, they changed retroactively. There are at least over 40 class action lawsuits that I know of in our industry, primarily along the Central Coast, but also in the Central Valley. It's had an enormous impact on employers, but not just employers. It's had it on employees and crews of companies farms that are no longer hiring, and on the communities in these farm towns that rely on these wages. I would urge an aye vote. This is a compromise bill that's fair to both employers and employees. It gets money to the employees. It clarifies the rules going forward, which is just as important. We'll know what the rules are. We can follow the rules, and we can sort of move forward with this. I urge an aye vote on behalf of our growers, who are our independent growers, and behalf of the agricultural community. I urge your aye vote.
Thank you. Next.
Thank you. Melissa Poole with the wonderful company, formerly Paramount Farms and Paramount Citrus. We're a large ag employer in the state, and piece rate compensation is a part of our business. It's a critical component of our labor practices. The two recent decisions, and I don't want to be too repetitive, but these two recent decisions have thrown that system completely out of whack for both employers and employees. And what this legislation really does is create the certainty necessary so that we ensure that we are paying our employees, that we compensate on the piece in the fair way, and we know how to do it, and the employees know how it's going to work moving forward. We are in support of this legislation, and we urge an aye vote. Thank you.
Thank you.
Mr. Chair and members, Caitlin Vega for the California Labor Federation. We are here in support, but we come at this issue kind of from a different direction. For many years, longer than I've been at the State Fed, there have been bills advanced to try to address the challenges faced by piece rate workers. Originally, piece rate was very common in agriculture, as you've heard. We're now seeing it throughout the economy. Even warehouse workers are being paid on piece rate. And what we see is that creates an incentive for workers to work nonstop and to never take their breaks unless they know that they're going to be paid at that higher rate, because of course these are very low wage workers who are working as hard as they can, as many hours as they can, and they want to work at the highest rate that they're able to do. And so we have tried for many years, along with organizations like the California Rural Legal Assistance Foundation, to advance legislation and to support bills that would address this and that would try to ensure that piece rate workers know that when they take that rest, they will be paid at that higher rate of pay. These are often jobs where there are very serious threats to health and safety if workers don't take breaks. And so that is what we feel like is the most important piece in this bill, and that this is a balancing act. We're trying to come to a negotiation. This is something that was negotiated by a couple of our unions that represent members. The Teamsters Union, for example, has members in all kinds of industries that are paid on piece rate, whether it's drivers, whether it's warehouse workers, and of course the machinists do too. And so they negotiated this deal thinking about how their members would be impacted and how do we create the right incentives for non-union workers who don't have anyone advocating for them, who don't have a union contract to protect them, to ensure that they are able to rest when they need to. So that's why we're here in support. Thank you.
Thank you. All others, please step forward in support.
So I'm Ralph Lightstone with the Labor and Workforce Development Agency, and I want to thank the author and all of the parties that have worked so hard on this. The administration has been committed, and people have put in hundreds of hours on all sides trying to get a resolution here that works for everybody. It's been a tough, hard-fought, and committed effort by a lot of people, and really appreciate it. It's a high priority for the administration to get this done because it helps workers. It gets pay in their pockets, it helps employers, and gives clear rules going forward. And I think that's the essence of what a good compromise is. So I just want to underscore how important this is for us to get it done. Thank you.
Great, thank you. Any others to support?
Good afternoon, Mr. Chair and members of the committee. Matthew Allen, representing Western Growers Association, and we have a support if amended position on the bill. Many of our members have been victimized by class action lawsuits stemming from the appellate court rulings requiring employers to separately compensate employees earning piece rate compensation for rest and recovery periods and other non-productive time, and creating retroactive exposure to huge fines, penalties, and attorneys' fees. Our board was apprised of the elements of this legislation in July and was satisfied that we could support it if the language did not stray from what we understood it would come out to be. Unfortunately, in this bill, there is included a late added provision that singles out a single company and blocks that company from utilizing the safe harbor provisions at the heart of the bill. The basis for singling out this business is that it has been alleged by the UFW to have used fictitious employees to engage in wage theft. It is patently wrong to deny one business that relief afforded by the legislature. to other businesses facing the same class action liability based on unproven allegations. Should this provision remain in an enacted statute, the new law may be vulnerable to an equal protection challenge, and we believe this should give you some pause. In addition, we note that this provision is not germane to the bill's overall purpose, and that is to set policy for compensation of rest and recovery periods and other non-productive time for employees compensated on a piece rate basis, and to provide a voluntary method for employers facing class action exposure to make employees whole without facing predatory lawsuits. Introducing a provision that links unproven allegations of unrelated wage and hour claims to resolution of the piece rate litigation conundrum is simply wrong from our viewpoint. Section G5 on page 9 of the bill should be deleted, or at the very least modified, to prohibit an employer from using the safe harbor provisions for piece rate litigation exposure where so-called ghost employee claims against that employer have been determined and established, not just merely alleged. An amazing amount of hard work and compromise has brought this legislation to this point, and we urge you to remove this unrelated and unfair provision from what is otherwise a balanced solution that would speed compensation to thousands of our workers and alleviate the potentially bankrupting threat of unanticipated class action lawsuits. We appreciate your time. Thank you.
Thank you. Thank you. Anybody in support? Anybody else in support? Please step forward and state your name and company.
Thank you, Chairman Doza, members of the Senate. Mark Martinez, Vice President of Public Policy for the California Strawberry Commission. On behalf of our 400 California strawberry farmers, we're in support of this bill.
Great. Thank you.
Good afternoon, Mr. Chairman. Brian Little with the California Farm Bureau Federation. We'd like to thank everyone from the administration and others who have worked so hard to bring us to a point where we almost have a solution to this problem that badly needs a solution. We have serious concerns, however, about the ghost worker provision that my colleague from Western Growers described a few minutes ago. We have some serious concern about that because we think that it's really not fair to deny someone access to a safe harbor merely on the basis of an accusation of wrongdoing rather than actually having been found to have committed that wrongdoing. But again, we'd like to thank everyone who's brought this legislation to this point. Thank you.
Thank you.
Good afternoon, Chair and members. Tricia Geringer with Agricultural Council of California, and we are in a support if amended position as well. Just want to echo Western Growers' viewpoint and their perspective on the ghost provision. Thank you.
Great, thank you. I know before we bring the opposition, I know that the committee staff has been working with proponents of the bill to try to help alleviate the concerns of the new car dealers. And I know that there's some agreement already that we've been kind of working on, so we'd love to bring up the opposition now and maybe beginning with the new car dealers to kind of clarify that.
Mr. Chair and Senators, Cliff Costa on behalf of the California New Car Dealers Association. I'd like to thank the chair, his staff, the committee staff, as well as the proponents of the bill for listening to our issues and as it relates to the California new car dealers here in California. Specifically, the Gonzalez case was against a car dealer. We have immediately after the Gonzalez decision have instituted a change in our pay plans where we pay double minimum wage because the techs bring their tools plus a performance bonus. We have been sued. We have been the focus of a ton of lawsuits. We've entered into a ton of settlements. We are concerned about the retroactivity portion of the bill, in other words, the safe harbor provisions. With sitting down yesterday, spending the time with the chair, and it looks like if the dealers are carved out of sections B, C, D, E, and F of the bill, as well as clarify that subdivision A is prospective only, as well as if we can work on an issue as it relates to how you put non-productive time on the itemized wage statement. With those amendments, the California new car dealers will be neutral on the bill. I'm happy to remove our opposition with that. And I'd like to once again thank the chair and his staff. Thank you.
Great. Thank you. And those amendments are being worked on, and we'll be taking them on the floor to ensure that we vote on them with those amendments that we just mentioned. Okay. Yes. Can we bring forward the opposition, please?
Mr. Chairman, members of the committee, Louis Brown on behalf of the California Fresh Fruit Association, California Cotton Growers and Ginners Growers Associations, Nisei Farmers League, Western Agricultural Processors Association. It's really tough to be here in opposition, especially when friends are on both sides of this issue. But the thing that perplexes us most, and we heard it from the author's statement, we heard it from the sponsors or the supporters, is that these two cases created a significant change in the law. I think we all agree on that. So our question is, if it's created such a significant change, why are people being left out? And that's our biggest problem with this bill, is that a year ago, this idea was being negotiated and language was being sought after to fix this, but it couldn't be resolved. But at that point, we had a date in which employers who face litigation could opt in to the bill. That date was only a couple months after the court decisions became final, which really made a lot of sense. People were just then becoming aware of these lawsuits. They didn't have time to change their practices, and yet suits were being filed. This year's bill, now for some reason, puts the opt-in date at March 1, 2014. That's 18 months after the suits were finished. There are any number of lawsuits that have been filed at that point. We know of one in particular, a member of ours, that will not be allowed the opportunity of the safe harbor provision because of that date. So we think that if the law would change so significantly, and if we're in the business of making sure that workers get paid and compensated without going through long, lengthy litigation, then why aren't all employers offered the opportunity to the safe harbor? We have the same concerns with the ghost worker provision. So the bill eliminates someone's opportunity to opt in because a claim was made. A non-Bluford claim, a non-Gonzalez claim, was made in an action. Not that it was finalized, not that it was determined by the court. And so we know of only one instance where that's taken place, and again, a member of ours in the San Joaquin Valley who has a class action lawsuit. So we believe that, no doubt, there's been a lot of work. And are any deals perfect in this building? No. But when it comes to talking about safe harbor provisions for the purposes of providing justice to workers, why are we picking winners and losers? And that's what AB 1513 does right now. Those provisions pick winners and losers. So for those reasons, we're opposed to the bill. Thank you.
Good afternoon, Mr. Chair and members. Savina Takar with the Consumer Attorneys of California, and we unfortunately have an opposed unless amended position on this bill. We are in support of the protections going forward, codifying Bluford and Gonzalez. However, the retroactive component is our reason for opposition. Attorneys and workers have pursued these cases during the retroactive period, starting March 1, 2014 on forward, based on the existing law at the time, which were these favorable cases. And the fundamental problem with retroactivity is that it takes away people's rights, and it actually could be constitutionally suspect. We've requested an amendment that we provided with the committee staff as well as the author that would remove our opposition. I'm happy to answer any questions. I'd like to share my time with our board member, Bill Turley, who's here to explain how the retroactive effect in this bill has affected the truck drivers or will affect the truck drivers in his cases.
Thank you. I'm a class action lawyer, and I've been living with these cases and living with these people for years and years and years. These are people I represent and proudly represent. The problem with this bill, going forward, it's great. All the provisions going forward are fantastic for every worker in California. We'll be the first to tell you that. I represent more drivers than any lawyer in California. I don't know of any lawyer in America that represents more drivers than myself. So for all my Teamster clients, this is fantastic. But for the non-union drivers, this is terrible. Let me tell you why. First of all, most of drivers, when they're talking hundreds of thousands of drivers here, are talking about that drive on a piece rate basis. 40% of their time is non-compensated. They get paid either by the trip or they get paid by the mile. So what you're going to see is all the things related to safety, pre-trips, post-trips, CHP stops, inspections, weighing, all that stuff there, they don't get paid for. And also, in addition to that, they're not loading and unloading and waiting at the loading dock. So over 40% of their time is spent and is non-productive. It's non-productive to who? It's productive to the employer. Every one of those tasks has to be done and help the employer. So what you're going to see is giving these workers 4% retroactive going backwards when 40% of their time is spent doing this is patently unfair. This is a giveaway to the employers. And so that's one of our main problems. You know, this is the deal, is my dad drove a bread truck, and he got paid by the piece rate. I saw what happened when you couldn't put food on the table, when you struggled to make ends meet, when you couldn't buy Christmas presents. I saw all that happen firsthand. I know how this affects families. And so going forward to say you only get 4% of the wages that are owed to you, I have to disagree with people here, and I respectfully disagree. This was not a change of the law. This has been the law in California since 1992, and 1194 was passed. You have to pay for all time worked. This is not something new to California. This is the Bible I live by, wage theft in America. Everyone here should read this Bible. This is the best book that's ever been written about what we're talking about today. This is nothing new. People suggest, oh, this is the new, the Gonzalez case was new. No, it wasn't. The Armenta case, years back, established you have to pay workers in California for all time worked. I've been a class action lawyer for a long time. I've represented the workers in the Brinker case, Brinker versus Superior Court, the largest California Supreme Court case on worker rights that's come out in years and years. I know this law. If it suggests this is something new, all of a sudden there's a fire, unfortunately that's not true, folks. What's true is that this is a giveaway to the employer. So this retroactive feature, I urge you to reconsider that. Thank you so much.
Thank you. Any others in opposition?
Mr. Chair and members, Mike Belote on behalf of the California Employment Law Council. You know, let's make no mistake, the notion of clarifying and providing certainty coming out of Gonzalez and Bluford is a worthy objective. This really is an important issue, but it's also very complicated legally. When this came out last Thursday, we've had lawyers poring over it, and there are a series of ambiguities in the bill, both on the going backward and the going forward portions, that we think need work. And we've had good discussions with the proponents and with the labor agency, and I think there is progress being made, but the bill has ambiguities. It has ambiguities with respect to the tolling of the statute of limitations, for example. That's on a going backward basis. On the going forward, again, let's make no mistake, one of the most fruitful areas of litigation in employment law in California is Labor Code Section 226. That is the pay stub law. And what the bill appears to require is anyone who has non-compensated time to put the number of hours of non-compensated time on the pay stub under Labor Code 226, even if all hours are being paid for. Now, I understand from discussions with the agency that there is a willingness to clarify in some way that if you pay at least minimum wage for all hours worked, you don't have to separately account for this non-compensated time on the pay stub. But that's a big deal. Imagine being in a variety of piecework locales where you're clocking in and out for potentially very short periods of non-compensated time. The machine breaks down for 8 minutes or something. You will have litigation coming out of Section 226. That will be a problem. So, the agency has expressed a willingness to clarify that. I think that would be a very salutary improvement in the bill. But there are some ambiguities in the bill that we're still working with the proponents on. Thank you.
Okay. Thank you. Others in opposition?
Thank you, Mr. Chair. Members, Mariko Yoshihara with the California Employment Lawyers Association. Also here to express the same concerns for Legal Aid Society Employment Law Center. Our organization, we have a lot of nonprofit attorneys as well who would be impacted by this case, and we have a lot of the same concerns as the consumer attorneys, mainly the retrospective piece to it. We have a lot of attorneys that have put in over hundreds of hours. They've been working on these types of cases for over a year, and now they're going to be in a position where they have an ethical duty to represent their clients, represent these workers to recover their past wages, but also knowing that they could lose everything with this affirmative defense. And so in that position, it's impossible. You have this ethical duty, you have these financial obligations, a fiduciary duty. So it puts them in a really difficult position, whether to keep pursuing the litigation or, you know, what exactly do you do at that point? And so That issue needs to be addressed. We feel like for the work that they've already put in, there should be some mechanism to ensure that they are able to recover the attorney's fees and costs for, to basically make sure that they're able to see that case through and represent their workers. Okay, thank you.
Thank you.
Good afternoon, Chairman, members of the committee. My name is Laura Brown. I work with California Citrus Mutual. We're a grower trade organization representing the state's citrus growers. When we learned about the wording in this bill, I sat down with a few packing houses and employers, small, medium, large-scale employers, and we ran through some calculations. And unfortunately, this is still going to be a very difficult process for us to engage in with the bill as it's written. We would have appreciated a little more time to consider how the program could be put together to encompass more industries, including smaller scale agricultural employers that are going to be at risk of going out of business if they were to comply with a program like this, if they were to optionally opt in. So on that note, I'd like to support that we remain opposed to this bill as it stands now, because at this point, the dynamics of our industry, we just can't implement the bill as it stands now.